Maine has an increasingly tenant-protective approach to rent increases that reflects the state's growing emphasis on housing stability and affordability. If you manage rental property in Maine, the framework has been evolving, and recent legislative activity has added new requirements that landlords must understand. The governing law is found in Maine Revised Statutes, Title 14, Chapter 709 and 710, along with local ordinances that have introduced rent regulation in the state's largest city. Maine does not currently have a statewide rent cap that limits the dollar amount or percentage of a rent increase. At the state level, a landlord can technically raise the rent by any amount, provided they follow proper procedures and the increase isn't motivated by an illegal purpose. However, and this is where Maine's landscape has changed dramatically, the state does not have a preemption statute that prevents municipalities from enacting their own rent regulations. This absence of preemption has allowed Portland, Maine's largest city, to enact rent control, making it one of the first cities in New England to do so in decades. Portland voters approved a rent control ordinance through a ballot initiative that caps annual rent increases for covered units. Under Portland's ordinance, the maximum allowable annual rent increase is tied to the Consumer Price Index. The percentage cannot exceed the CPI increase for the applicable period. The ordinance covers most residential rental units in the city, though there are exemptions for certain property types, including owner-occupied buildings with a limited number of units and newer construction for a specified exemption period. Portland's rent control program includes a process for landlords to petition for increases above the CPI cap when they can demonstrate that their operating costs have increased beyond what the cap allows. The petition process requires financial documentation and is reviewed by the city's rent board or designated administrative body. Tenants have the right to contest petitions, and the process can be detailed and time-consuming. Portland's ordinance also includes provisions regarding banking, whether unused increased capacity from one year can be carried forward to a future year. The specific rules on banking have been subject to debate and amendment, and landlords in Portland should verify the current provisions. If you own rental property in Portland, compliance with the rent control ordinance is mandatory. Exceeding the cap without an approved exemption or petition can result in penalties, tenant remedies, and enforcement action. Landlords in Portland should treat the CPI cap as a hard ceiling and plan their pricing strategy accordingly. Other Maine municipalities have been watching Portland's experience and considering their own rent regulation measures. Bangor, Lewiston, South Portland, and other communities have seen political discussions around tenant protections and affordability. While no other Maine municipality has enacted rent control to date, the political trajectory suggests that additional communities may consider it. The state legislature has also debated statewide rent regulation proposals, though none have been enacted. For properties outside of Portland's rent control program, which includes all properties in the rest of the state, the landlord can set rent based on market conditions without a cap. For tenancies at will, Maine's term for month-to-month arrangements, the landlord must provide advance written notice before a rent increase takes effect. Maine requires at least 45 days written notice before a rent increase becomes effective. Under Title 14, Section 6015, the landlord must provide at least 45 days notice before the effective date of the increase. This is longer than the 30-day standard used by most states and gives Maine tenants meaningful time to evaluate the increase and plan accordingly. The 45-day notice period applies statewide. In Portland, the increase must also comply with the CPI cap for covered units, so landlords in Portland need to satisfy both the notice requirement and the cap. The notice must be in writing and should clearly state the current rent, the new rent amount, and the effective date. The notice should be delivered by a documented method: personal delivery, certified mail, or another verifiable means. For fixed-term leases, the rent is locked in for the duration of the lease term unless the lease includes a provision allowing midterm increases. At renewal, the landlord must provide the 45-day notice of any proposed increase. In Portland, the increase at renewal must also comply with the CPI cap for covered units. When the lease approaches expiration, the landlord should make pricing decisions and deliver the notice well in advance. For week-to-week tenancies, the notice period for rent changes is 7 days under state law. Now let's talk about how Maine's just cause eviction protections interact with rent increases, because this is increasingly relevant. Portland enacted just cause eviction protections, and the state legislature has considered statewide just cause measures. In jurisdictions with just cause protections, a landlord cannot use a massive rent increase as a tool to force a tenant out. If a landlord raises rent to an amount clearly above market rate with the apparent intention of making the tenant leave rather than reflecting a genuine market adjustment, the tenant could potentially challenge the increase as a constructive eviction or as a violation of just cause protections. This doesn't mean landlords can't raise rent to market levels. They can, but the increase must be justifiable based on market conditions and business factors rather than appearing to be a pretext for removal. Now let's cover the restrictions that apply statewide. Rent increases cannot be retaliatory. Maine has a strong anti-retaliation provision under Title 14, Section 6001, that prohibits landlords from raising rent in retaliation for a tenant exercising their legal rights. Protected activities include making a good faith complaint about habitability to a government agency, reporting a code violation, exercising any right under the landlord-tenant statutes, participating in a tenant's organization, and testifying in any proceeding related to the landlord's obligations. Maine's anti-retaliation statute creates a rebuttable presumption of retaliation if the landlord takes adverse action within 6 months of the tenant's protected activity. 6 months is a meaningful protection window. Any rent increase delivered within that period after a tenant's complaint carries an automatic inference of retaliatory motive. The landlord must then demonstrate that the increase was motivated by legitimate business factors entirely unrelated to the tenant's protected activity. The consequences of a retaliatory rent increase in Maine can include liability for actual damages, attorney's fees, and the invalidation of the increase itself. The finding can also undermine the landlord's credibility in any related legal proceedings. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the Maine Human Rights Act, found in Title V, Chapter 337, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, sexual orientation, gender identity, disability, familial status, age, ancestry, or receipt of public assistance. Maine's anti-discrimination protections are significantly broader than the Federal Fair Housing Act. The inclusion of sexual orientation, gender identity, age, ancestry, and receipt of public assistance provides extensive additional categories. The receipt of public assistance protection is particularly relevant to rent increases. A landlord cannot raise rent specifically to push out a tenant who receives Section 8 vouchers, TNF benefits, or other government assistance. A rent increase that appears targeted at subsidy recipients while other comparable tenants are not similarly affected can result in a discrimination complaint with the Maine Human Rights Commission and significant liability. From a practical standpoint, Maine's rental market has been one of the most rapidly changing in New England over the past several years. Portland is by far the state's largest and most active rental market. The city has experienced significant rent growth driven by a combination of factors: a desirable coastal lifestyle, a growing food and creative economy, healthcare employment, proximity to outdoor recreation, and an influx of remote workers and retirees from higher-cost markets. Portland's rental vacancy rates have been extremely low, giving landlords significant pricing power. However, the rent control ordinance now constrains annual increases for covered units to the CPI percentage, which limits revenue growth regardless of market demand. Portland's rent control has created a dual market: covered units with CPI-capped rents and exempt units, including newer construction during their exemption period, that can be priced at market rates. This gap between controlled and market rate rents is likely to widen over time as market rents increase faster than the CPI cap allows. South Portland, Scarborough, and other Portland area suburbs have seen spillover demand from tenants priced out of Portland proper. These communities don't have rent control, and landlords have been able to implement increases that reflect the market. However, the political conversation about rent regulation extends to these communities, and landlords should stay informed about potential local measures. Bangor, Maine's third-largest city, has a more affordable rental market driven by healthcare, the University of Maine system, and regional commerce. Rents have increased but at a more moderate pace than Portland. Bangor offers moderate pricing power for landlords. Lewiston and Auburn, the Twin Cities in central Maine, have some of the most affordable rents in the state. These communities have seen population growth driven in part by immigrant and refugee resettlement, and the rental market has tightened somewhat. Pricing power is more limited than in Portland or the southern Maine coast. The mid-coast and down-east regions, including communities like Rockland, Camden, Bar Harbor, and Ellsworth, have rental markets heavily influenced by tourism and seasonal demand. Summer rents in tourist communities can be dramatically higher than winter rates, and the seasonal worker housing shortage has been a persistent challenge. Year-round rental demand is more limited in many of these communities. The Kennebunk, Wells, and York area in southern Maine has strong demand driven by proximity to both Portland and the Boston metro area. Rents in these communities have increased as the broader southern Maine market has tightened. Brunswick, home to Bowdoin College and the former Naval Air Station, has a tight market influenced by the college and the redevelopment of the base property. Bath, home to Bath Iron Works, has rental demand tied to the shipyard's workforce. Rural Maine, particularly the northern and western parts of the state, has softer rental markets with limited pricing power. Population decline in many rural communities has reduced demand, and landlords need to be conservative about increases. One critical best practice for Maine landlords: if you own property in Portland, understand every detail of the rent control ordinance. Know the current CPI cap, the exemptions that may apply to your property, the petition process for above-cap increases, and the filing and notice requirements. Non-compliance can result in penalties that exceed the revenue from the increase. Working with a Portland attorney or property management professional who specializes in the rent control program is strongly recommended. Another best practice, given Maine's 45-day notice requirement, plan your rent increases well in advance. If you want an increase to take effect at a specific date, count backward 45 days and add a buffer for delivery time. Missing the notice window delays the increase and can cost you revenue. For landlords operating in both Portland and other parts of the state, maintain separate procedures for Portland properties subject to rent control and other properties that are market rate. The compliance requirements are different, and a one-size-fits-all approach can result in violations in Portland or missed opportunities elsewhere. Maine's seasonal rental market creates additional considerations for landlords in tourist areas. The regulatory framework applies to all residential tenancies, regardless of duration or season. So landlords who rent seasonally must still comply with the 45-day notice requirement and all other statutory obligations. Understanding how the landlord-tenant statute applies to seasonal arrangements helps avoid compliance gaps. For Maine landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority. In Portland, the increase must also comply with the rent control cap. The housing authority's approval doesn't override the local ordinance. The most restrictive limit applies. Submit increase requests well in advance. Maine requires landlords to return the security deposit within 30 days of the tenant vacating, or within 21 days if the tenancy was terminated due to foreclosure. Maine limits the security deposit to 2 months' rent. While these rules don't directly regulate rent increases, landlords should understand that increasing rent doesn't automatically entitle them to collect additional deposit from an existing tenant without a new agreement. For the complete guide to Maine rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.